Hello, welcome back to Deb's True Crime Notebook. It is a busy day today. It's now 5:49 p.m. here in Indiana, and we've got more information for you, more documents, all coming in at the last moment because, of course, tomorrow is the sentencing date for Richard Allen. So let's get right into these. So these are the things that have been filed today. They have document filed, a victim impact statement. Not sure who that is from, but one of those has been filed. A notice of exclusion of confidential information has also been filed. A defendant's motion to preserve evidence has been filed. A motion to refer to state public defender for appointment of appellate counsel has been filed, and of course Judge Gull has filed the sentencing hearing to begin tomorrow morning at 9 a.m. So first up is the motion to refer to state public defender for appointment of appellate counsel. Richard Allen, by counsel, moves this court to refer this case to the state public defender for appointment of direct appeal counsel. In support of this motion, Defendant Allen states the following. 1. Defendant Allen anticipates that subsequent to the sentencing hearing scheduled on December 20th, 24, he will file a notice of appeal with the Indiana Court of Appeals. 2. Carroll County's Comprehensive Plan for Indigent Defense Services permits this court to refer the case to the State Public Defender's Office for appointment of counsel if an attorney is not qualified or available, or if referral to the state public defender would be in the interest of justice. 3. Failure to follow the county's comprehensive plan for appointment of counsel jeopardizes the 40% in reimbursement the county receives for indigent defense services. 4. Defendant Allen's trial counsel believes that no individual appellate attorney will be able to manage the volume of information in this case under the tight deadlines required by the Indiana Rules of Appellate Procedure. Trial counsel further believes that it is in the interest of the judicial economy that this court facilitate the appointment of multiple appellate lawyers to prosecute Defendant Allen's appeal within a reasonable time and to further avoid the possibility of lengthy continuances and delays, which most certainly result from the appointment of any one attorney to handle this appeal. 5. The state public defender has a carefully curated list of appellate attorneys who have handled complex cases with large records on appeal, as this case will be. 6. The state public defender can consult attorneys on her list who are qualified and can work together on the appeal to ensure the deadlines are met and to ensure that the appeal is processed with efficiency and in the interest of judicial economy. 7. A referral to the state's public defender's office will also promote a more neutral and detached appointment of appellate counsel so as to avoid any sense of impropriety that might otherwise be associated with the appointment of local counsel in or near Carroll County or counsel in Allen County, where hearings had been previously scheduled and conducted in this case. And 8. Referring Defendant Allen's case to the state public defender for appointment of appellate counsel is in the interest of justice. Respectfully submitted, Bradley Rosie. Okay, next document. Defendant's motion to preserve evidence. Defendant Richard Allen, by counsel Andrew Baldwin, respectfully requests that this court, 1. Order the state, including any law enforcement agency holding evidence in the above captioned cause, to preserve all evidence for possible future testing, inspection, or admission at a hearing. This request is being made pursuant to the Due Process Clause of the 14th Amendment to the U.S. Constitution and Article 1, Section 12 of the Indiana Constitution. 2. Preserve all documents related to the jury venire in this cause, including but not limited to the unredacted versions of the juror questionnaires. This request is being made pursuant to Indiana Jury Rule 10, which excludes jury questionnaires from being publicly accessible but contains no limitation on the party's right to obtain juror information. This is to certify a copy of the foregoing pleading has been provided to all counsel of record for the opposing party via IEFS the same day of the filing, signed Andrew Baldwin. So that's what we have so far in the way of new documents for today. If there's anything else that comes across our desk, we'll bring it to you. Otherwise, we'll talk to you tomorrow with coverage of the sentencing hearing. Thanks for watching Deb's True Crime Notebook. Don't forget to like, share, follow, subscribe, ring the bell for all notifications, and leave us a message. We'd love to hear your comments.